Hello and welcome. So for today's presentation, we're going to be talking about the 3 hidden secrets your IP attorney held from you. So I gave this presentation or similar presentation yesterday, and I always want to clarify they didn't hide it from you because they're bad people, right? They hid it from you because unless the IP attorney is thoroughly familiar with Amazon practices and Amazon sort of pitfalls and opportunities, they might have neglected to mention it to you. So that's what we're going to talk about, the 3 hidden secrets. And secret number 2 actually has resulted in almost $500,000 of funds back to our client's pocket. So stay tuned. A little about me. So Mario Simonyan, I've built and sold 2 7-figure Amazon private label brands. Afterwards, I founded Esco, and our law firm works exclusively with Amazon third-party sellers. We were fortunate enough to be the recipient of Law Firm 500 Award for last year's performance, where we were ranked the 3rd fastest growing law firm in the nation. I've also, for the last 3 years, been named by Super Lawyers as a rising star. Only 2.5 of attorneys received that award. And earlier this year, I released my first book, turned out to be a best-selling book called On the Corner of IP and Amazon. And of course, that's available on Amazon.com. And also practiced or authorized to practice law in California and Washington state, where Amazon is. So because we're barred in or allowed to practice law in Washington state, we can help any Amazon seller across the country and really across the globe. And then our practice areas, you guys already know about Amazon law. We help with that. So any issues you have with Amazon, the marketplace, or competitors on Amazon, we could help you. Any issues with Walmart, we could help you. And of course, IP. So trademarks or copyrights or patents, we can help you with that, both registering and enforcing your IP rights. So before we get started, let me just do a quick overview of IP. So there's 3 branches of intellectual property. There's trademarks, there's copyrights, and there's patents. One easy way to remember this is trademarks. We're talking about logos, we're talking about slogans, we're talking about a brand name. Copyrights, we're talking about artistic work. So any books that you write, any movies that you create, any poems, anything that requires artistic content, you can go ahead and protect with a copyright. Most Amazon sellers, when we're talking about copyrights, really they're protecting their product photography that they have with copyrights. And then patents, anytime you hear patents, just think of inventions. Okay. So secret number 1, trademarks and patents are for sale. So just like if you have real estate, if you have a home, whether it's commercial or residential, you can sell that. You can buy and sell. Same thing with intellectual property. You can purchase the rights to intellectual property. So if you have a trademark or a patent or a copyright, you can both sell that and also purchase others, right? A few rules. So for trademarks, what you don't want to do is purchase a naked trademark. What does that mean, right? Because a trademark belongs to a brand, it protects the reputation of a brand, right? So you can't buy the trademark just by itself. It has to come with something else. It has to come with a brand. What does that look like? It's what the USPTO and trademark law calls goodwill. So it might be a website, it might be a Facebook page, it might be a brick and mortar store, but it has to come with something in addition to just the USPTO trademark. Otherwise, it's considered a naked trademark and it's not going to be valid. The transfer or assignment from seller to buyer won't be valid. So just keep that in mind. And there is a large marketplace for trademarks for both purchasing and selling. It's called the U.S. Trademark Exchange. The owner is a good colleague of mine and also has been in the industry for, I want to say, 20 to 40 years. So that's the website. And this is what the website looks like. So you'll see these are trademarks for sale. you'll see the price on the right-hand side anywhere from $15,000 all the way to, what is it? Someone listed it for $9.7 million, right? I don't know if he's going to get that, but it's all negotiable. So just something to keep in mind. Something else you'll see on the website is trademarks for licensing. Licensing is renting it out. So just like, again, going to real estate, if you have a home, you could rent out your home. You don't necessarily have to sell it. You could give someone temporary access to it or control to it. Same thing with IP, with intellectual property. You could go ahead and license it. Licensing usually comes out or is at play with larger brands, larger companies. For example, with Disney, you could go ahead and license Mickey Mouse or the Avengers, because Marvel is now owned by Disney, or anything else, right? Just some general things for you guys to know. Licensing terms, it could be several different flavors or terms. Flat fee, it could just be, here's $50,000 and I want to be able to use it for 1 year for 10,000 units. Or it could be a percentage of revenue. You could use it for the next 5 years, for example, but off of each sale, we want 5% or we want 10%. That would be the licensor or the owner collecting that from the licensee, whoever is renting it. Or it could be a hybrid. It could be a hybrid of both those. It could be a flat fee up front plus a revenue percentage. So just keep that in mind. Couple helpful tips about trademarks. So not just trademarks, I guess, but just with IP. If you guys are registering IP, make sure it's owned by the legal entity and not by yourselves. It's just good practice that the IP is owned by the company. So if you've got ABC LLC, then it should be owned by ABC. Your trademark, copyright, or patent should be owned by ABC LLC instead of you as an individual. Helps keep privacy. So now they're not sure, or at least your information is not out there public as far as who owns it. Your address, your physical address isn't there, but also for accounting purposes, again, talk to your CPA, but it's always good practice. Here at ESCO, we've got probably half a dozen trademarks and all of them are owned by ESCO. I don't own any of them. And then we've had several questions about when can I use the R in a circle versus just TM. The R in a circle, that's reserved for trademarks only. So if your trademark is registered, that's really what the R means, is registered, then you could use it. Otherwise, you're not allowed to use it. There are sort of fines and penalties you may face, but I've never seen that being enforced. And then TM can be used by anyone who intends to protect their trademark or their brand name. They could just put TM. Doesn't really carry much legal weight behind it, but that's a practice that some brands, big and small, both use. Next, still on secret number 1, buying and selling patents. So with trademarks, a trademark can be valid indefinitely. So a trademark can be passed on to your kids, your grandkids, your great-grandkids, as long as the trademark is being used, as long as that brand is around and involved in commerce. So you can't just get a trademark and put it under your bed or put it in your file cabinet and never use that brand name or that mark again. However, with patents, you can't do that. There's millions of patents or patents that were created by inventors who have never seen the day of light, meaning they've never actually produced a product, right? They never brought a product to market. So patents are still valid. They don't need to be used in order to maintain its validity. So again, patents can be purchased and sold. And one important thing is with patents and with really all IP, they're jurisdictional. If you have a patent here in the United States, it's only valid here in the United States. You can't enforce it against someone who may be infringing in Canada, in Mexico, in Europe, or anywhere else. It's only valid here in the United States if you get it through the USPTO. There are ways to expand the protection of it to other countries, and we'll get to that later on, but just keep that in mind. And just like with trademarks, there are several marketplaces, one of them being patentauction.com, where you can purchase and sell patents or also license, right? So my thoughts about Amazon and where it's headed is I see the decline of online arbitration, of wholesaling. I see Amazon continuing to favor private label and white label, sort of this private brands, a lot more than just someone who's really a reseller. So Amazon is now backing innovation. So if you've got a certain brand or if you've got a patented product, then you're gonna, I think, carry a lot more favor with Amazon. And I think as time passes by, we'll see Amazon sway more and more in favor of people who have their own brands, who have their own products. Okay. So with that in mind, if you're not the most creative person to come up with a new idea, you could always go ahead and purchase or license someone else's patent, right? Someone else's invention. Obviously, there's a lot to discuss there, a lot of due diligence to be conducted. So my suggestion is always do that with the help of an attorney, a patent attorney, but that's something that you guys can do. If you guys are going to be dealing with manufacturers in China and really anywhere else, make sure you guys get a non-compete, non-disclosure agreement. It'll save you guys a lot of headache, a lot of time. We had a client who had a brilliant idea, takes the product, sort of the diagram to Asia and says, this is what I want to create. And I also want to be able to patent this. And the Chinese rep says, you can't protect this with a patent. Client says, okay, go ahead and manufacture it anyways. 2 days later, that same Chinese manufacturer calls their attorney here in the United States and gets a patent. How do we know all this? Because we're in litigation right now, and that's what happened. All right. Our client was fortunate enough to have all of that communication in black and white, in email, in text messages, and we were able to help, fortunately. But all because there was no NNN, right? So make sure you guys get your non-compete, non-disclosure, all of that done. It'll save you guys a lot of time and a lot of headache. And then one more thing with registration timeline, trademarks nowadays, because of the influx of trademark applications being submitted to the USPTO, trademarks you're looking at about 12 to 14 months. Design patents, you're looking at 18 to 24 months. And utility patent registrations can be 2 to 5 years, depends on the prosecution. Secret number two. Secret number two is avoid Apex. What's Apex? Apex is Amazon's Patent Evaluation Express program. It used to be called Amazon's Neutral Evaluation Patent something, something, something. They even realized how long and confusing that was, so they just shortened that to Apex. So with Apex, just a brief intro, the way it works, think of it as like a mini lawsuit. You would go ahead and file the application to join Apex. And nowadays, unless you have brand registry, you're unable to take advantage of Apex. Let's assume you do. You join Apex or file the application, you would list up to 20 ASINs that are infringing on your utility patent. Keep in mind, until now, this is only valid. Apex can only be used for utility patents. So once you file the application, the other side, these alleged infringers, can come and join the program, can go ahead and put up $4,000 and say, I want to join. At that point, you as the inventor would need to put up another $4,000, $4,000 bond. And it's very similar to a lawsuit. The inventor or the patent holder would go ahead and file the complaint, draft that, and say, I believe this person is infringing for this and that reason. Put all your legal arguments together. The other side would answer, and then you get a chance to respond to their answer. There's no discovery. Discovery is where both sides ask each other for documents, for information, and they're obligated to provide it to each other. and there's also no damages. The only remedy in Apex is to remove the other person's ASIN. That might sound good, but we've got a better solution. And that's why I said avoid Apex. So this is a program that we started earlier this year, and it's just been a miracle. It really has. This program, this service holds a special place in my heart. Our entire sort of being, this law firm that we've got, ESCO, is to provide online sellers, to provide Amazon sellers with creative yet logical solutions, right? Creative and logical. There's some ideas that are just off the wall creative where it's like, you know what, that's too sort of off the wall. It's not going to make any business sense. Our thing is, let's come up with ideas that make business sense, but are also creative. So what did we do with IPX, this program that we just created? If you've got over 50 infringers, we'll take your case on contingency, meaning you don't pay anything up front, no attorney fees. We'll go ahead and enforce your IP, whether you've got a trademark, copyright, or patent against infringers, and we'll go ahead and force them to settle and pay royalties. From there, whatever we collect, we would go ahead and distribute the royalties amongst attorneys and client, right? This is what I mentioned early in the morning. One of our clients, he's up to about $500,000 that we were able to collect for him. So this is a game changer. Now, it does have its advantages and disadvantages. So benefits, as I mentioned, $0 out of pocket for legal fees, right? We'll invest, we'll take on the risk, we'll take care of all the expenses. And a lot of our clients have called this an additional revenue stream, right? Because now you're able to monetize your IP and also permanently remove these infringers. These infringers that we remove, they'll go ahead and sign an agreement that says they're not going to infringe again. And if they do, then they're going to have to pay a fine, an additional fee, in addition to just infringing. So keep that in mind. Now, disadvantages. IPX is limited to foreign infringers only. So anyone that's infringing outside the United States, that's who this program is perfect for, this service. And it's only for situations where you've got widespread infringement. So over 50 infringers is what we're looking at. Otherwise, it doesn't make sense for us to invest all that money into finding and removing these infringers if you guys don't have over 50. And it's limited to online marketplace only. So if you've got an infringer on, let's say, at a brick and mortar store, we're not going to be able to go after them with this service. But any other way, any other marketplace, we could go ahead and definitely take advantage of this program. So that's Amazon, that's eBay, that's Walmart, that's Etsy, Alibaba, AliExpress, DHgate, any of them, we could go ahead and use IPX for that. And again, been a complete game changer. Secret number 3. So foreign registration for your trademarks. A lot of our clients have asked, does it make sense for me to get a trademark in China where I manufacture if I've already got a trademark here in the United States with a USPTO? And my answer is always yes, because there are people out there who, if they see that there's a successful brand on Amazon here in the United States, they would go ahead and file, these bad actors would file a trademark in China for that same brand name. So when it's time for you to go get that brand name, Chinese government will say, well, that's already taken by this other person. Then you would have to negotiate the purchase of that trademark from that person. These people are called trademark trolls. You can read all about them. But that's one reason. Number 2, if you're manufacturing over there and you see yourself manufacturing or continuing to manufacture for the next couple of years, then definitely suggest you get one. We already covered a few horror stories, but let's talk about the difference between directly filing a trademark with the Chinese government, with their trademark office, versus doing it through the Madrid Protocol. Madrid Protocol is sort of a treaty amongst several countries. China and the United States are part of it, that says if you have a trademark here in the United States, you could expand that onto into other countries by leveraging the trademark you have here in the United States with the USPTO. The other one is just hiring an attorney to file directly with the Chinese government, your trademark. So those are two different avenues you could take. Now, benefits of going through the Madrid Protocol is if you're going to be filing in more than in 2 or more countries, it's usually more cost effective and it's a simpler process. Disadvantage to that is it all hinges on your trademark registration here in the United States. So if anything happens to your US trademark here in the United States, those other trademarks that you've obtained through the Madrid Protocol would be in jeopardy. So that's one of the disadvantages. The advantage of going to just directly China is if you're just doing one country, it makes more sense, more cost effective and faster to go directly to the country. And one thing that we've learned is if you're going to be dealing with any attorneys on that side of the world, we've got a few great partners that we work with over there, other attorneys, but we found that sending money to China directly is very difficult, very cumbersome. So there's attorneys in Taiwan that we work with who have branches in China, and it's a lot easier to send money to Taiwan from the United States than it is to send money from the United States to China. So just something for you guys to keep in mind. I don't see any Q&A in the comments, so I'll go ahead and skip this. If you guys have any questions, go ahead and post it underneath this video, and I promise we'll get to it. We'll get to all of the questions. And if you got any value out of this video, please go ahead and like and subscribe. We do these once a month and may increase the frequency and do these a lot sooner. But if you got any value, go ahead and like and subscribe. And if you have any further questions, go ahead and contact us. The contact information is right there. Thank you.